How the West was won. Hanging the innocent. Western movies often begin with the gravest of injustices, the hanging of an innocent man. The plot is often thickened by an unjust judge who knows he has hanged an innocent man. This most grave of all injustices opens the door to a riddle on a biblical scale. How can a judge remain just, yet accept the hanging of an innocent man in the place of the guilty? As morally wrong as this situation appears, we Christians believe such a bizarre thing actually happened. This riddle lays out one of the greatest moral challenges ever mounted against the heart of the Christian faith. Scholars that use this argument are so sure of the moral issue it raises, they're willing to grant to the Christian all of the classic arguments over the virgin birth, the miracles, and even the sinless innocence of Jesus, because the scholar's argument is based on the issue of whether or not the Father is a just judge. The reasoning is that even if Jesus had been sinless, the greater violation of justice would have been for the judge to apply the death of the innocent Jesus to the moral accounts of all the guilty. A just judge does not execute an innocent man in place of the guilty, even if the innocent man volunteers to die. In the next several minutes, you will learn how the solution to the riddle is linked to this presentation by an overlooked but marvelous legal feature of the family. This presentation is about an idea that has the power to change the course of history. It's a simple idea, but when understood and applied, it will bring much-needed change to every nation on earth. First, you will be equipped so you can see the significance of the idea. Justice is the great desire of the nations. This is because justice is concerned with our rightly managing our relationships with each other, which places justice within the sphere of ethics. So in a real sense, doing justice is doing right by others. Said in another way, doing justice is for me to do right by you. Everyone always needs everyone else to do right by them, which is the golden rule in a different wording. Always do unto others as you would have them do unto you. As Jesus taught, this is the meaning of the law and the prophets. The universal need for being treated right by others is what has brought about the creation of every court on earth. In turn, the need for justice creates the need for government. Justice is the reason of state. When the government is reduced to its one essential attribute, we're left with Deborah sitting under the palm tree in Ephraim, administering justice. Across the ages, courts have met under numerous great trees to do justice, and by so doing have demonstrated a myriad of times that doing justice is the essential purpose of government. The significance of doing justice is why all other functions of government are of secondary importance. And what does the Lord require of you but to do justice, to love mercy, and to walk humbly with thy God? Yet, within this context of significant thought, government actually has no existence other than existence as thought itself. This means the realm of government is to be found in the realm of thought. Government is no more than thought that functions as belief about how we ought to relate one to another. The Scripture teaches we are to relate to one another in the spirit of holiness. To be holy is to be pure, innocent in all you say and do, having no hidden motives, wronging no one. It is to be trustworthy at all times. To be holy is to be open-hearted and as transparent in spirit as the crystal sea before the throne. This is the spirit of little children and of the Lord himself. Holiness brings forth righteousness in the land. True holiness will separate you as well as the nations from all wickedness. You are to be holy as God is holy. In truth, Everyone in heaven and on earth is to walk in holiness at all times and in all ways. There is no real alternative. The Lord does not subject his court to the many false doctrines of justice that rise and fall with the nations. He will not ask our judges how faithfully they applied the doctrines of human rights in the cases they judged. He will ask our judges how faithfully they did apply the principles of holiness in the cases they judged. If the Lord is to judge justly, he must require everyone to walk by holiness at all times and in all ways. The standard is the same for all of his creation. This means the principle is the same for the nations as well as for you and for me. All nations are required to walk by holiness in all their ways. Otherwise, the nations cannot be judged by God's standard. Yet, we know from his testimony that every single nation will be judged. Holiness is the one and only truly character-producing ethic. In turn, holiness is the moral foundation for all relationships and the only valid basis for justice. Holiness born in you is what allows you to enter into his presence. In turn, righteousness is the relational fruit of holiness. Said in another way, righteousness is the outworking of holiness in relationships. Like everyone else, you must be born again if you are to trust these truths. This is the gospel of the kingdom, and this gospel of the kingdom must be preached to the whole world as a testimony to all the nations. Then the end shall come. Now, as stated, belief gives shape to the forms of thought. Belief even has the power to guide the direction of the flow of thought. This means belief guides the direction of government. Wrong beliefs form easily, and they quickly take on a life of their own. With little warning, wrong belief can turn justice into wormwood. This real danger means the court must exercise discretion or judgment on itself in deciding who or what association or what case will be allowed to appear before the court. Criminals will gladly use the power and the force of the court to achieve their amoral purposes. In contrast, the court cannot justly overlook the protection of even the smallest and poorest among us. The court's own history also dictates that it cannot justly overlook or refuse to see an association of persons if that association properly contributes to the well-being of society. Now we're winnowing down to the idea that has given rise to this presentation. In the late 18th century, the need for access to justice by an association known as a company gave rise in our courts to the creation and legal recognition of the modern corporation. This tells us, rightly or wrongly, the court now sees the corporation as contributing sufficiently to the well-being of society to warrant full protection under the law. In reaction, socialist governments decided to grant legal recognition to a different set of associations. Instead of the corporation, they grant court recognition to the cooperative. However, the only real difference between these two types of legal associations is who it is that owns the association. The point at this moment is that formal recognition in the court is the means by which these new types of relational institutions have been created. The corporation originally came into existence when a charter of incorporation was presented to the court, and the court placed its seal of acceptance on the charter. Even today, a corporation exists only because its creators have filed for its recognition in a manner that is acceptable to the court. The following illustration reveals why the creating or incorporating of such a legal set of relationships is of value for society. An employee of Cabinet Corporation drops a cabinet on a client's foot and breaks it. This creates a debt no one wants to pay. The issue is taken to court. The question is, who will the court subpoena to appear before the court to pay the debt? The answer is the 3 officers of Cabinet Corporation who are by law registered with the court are the ones who will receive the subpoena. Also, by law, these 3 officers are the president, the vice president, and the secretary of the corporation. These officers of the corporation are held responsible by the court to pay the debts created by all employees while on the clock. This structure of expanded yet controlled liability enables an immense growth in the size of working organizations or businesses, which has resulted in a true explosion in wealth. This means a corporation is a system for structuring legal accountability, which enables the functioning of a set of highly complex interrelationships that would otherwise be impossible. Its creation was an act of legal gymnastics that transformed the economy of nations, as well as the financial well-being of untold millions of families. These things mean a corporation's existence is rooted in a relatively new legal idea, at least relatively new to the mankind. Like the government, the corporation has no physical existence, but is an abstract set of legal ideas about how business can best be done. This means the corporation is a new set of court-recognized relationships. Since the government completely creates from nothing the legal structure of the corporation, the government is in a position to freely define the relational features of the corporation as the government sees fit. However, it is not unusual for judges to wrongly define the issues and make wrong decisions. These mistakes are often due to the judge's own wrong personal beliefs and attitudes. This has resulted in the court creating an unnecessary war of the worlds. The court versus the real family, and the importance of obtaining legal recognition as a means of protecting the real family. Now we're at the point in this presentation where the idea that will change the world can begin to take shape in your own thoughts. Whether intentional or not, the new definitions of the family which have been coming out of the court are also reducing the family to nothing more than a fluid legal idea. If the family is nothing more than an idea, then the court cannot be faulted for seeing itself as being entitled to reduce the family to nothing. One reason the court cannot be faulted is because our Constitution makes no mention of the family one way or another. So the family has the misfortune of not directly having constitutional protection. However, there are nations which have chosen not to have a written constitution at all. And many of these nations have also chosen not to legally attack the family. In contrast, the family hostile definitions coming out of our court could only be created by ignoring the absolute dominance of the physical elements of the family, which has then allowed the court to wrongly present the complexion of the legal elements of marriage and adoption. You could say there is an elephant in the court, yet the court refuses to see the elephant, which is eyeball to eyeball with the judges in their own chambers. The court's blindness to the family could be an honest oversight, simply because the court has not yet been put into a position where it must see the true family and then give the family the full legal credibility it undeniably deserves. So, is there a way we can put the court into a position where it has to see the real family? Yes, there is. The court must be challenged by a petition seeking the court's seal on a charter which will bring about the granting of full legal recognition to the true blood-based family. In turn, the charter should not be written by the court, but by a true family petitioning the court, or writing a bill for Congress to enact. The family should be under the guidance of its own non-governmental family specialist, as well as lawyers, including constitutional lawyers. This process should be pursued in much the same way businessmen 200 years ago pursued full legal recognition for the corporation. In contrast, not granting the family full legal recognition at any point over the last 200 years is what has freed the destroyers in our court to redefine marriage, adoption, and the family. However, if the family is anything more than a fluid definition, and if the family constitutes a set of biological relationships at the heart of all human life, and if the family is fundamentally living, breathing human flesh and blood, which gives to each of us our life through our parents, then the court cannot rightly reduce the family to nothingness. Reducing the family to nothing is essentially the step that is used to set the destroyers in the court free to build a fully arbitrary definition of the family, which will inevitably be a definition of the destroyer's own whims. The court began its systematic destruction of the family by redefining marriage and adoption. This process has been based on rebel doctrines of the moment, but the court has deviously called these rebel doctrines new insights. The process at this level may be happening because there is an agenda at hand, a covert agenda which is being driven by false beliefs rising among court members and their staff. Remember, false beliefs are powerful enough to override reality, no matter how educated the deceived believer may be, which means the pride which enables the court to decide to take on redefining the family constitutes nothing more in itself than a morally blinded approach which is sufficiently perverse to ultimately bring shipwreck to Western civilization. The court has created a false legal dilemma, unnecessarily, but knowingly bringing the promise of great conflict upon our land. None of the new court definitions are built upon or related in principle to the innate biological roots that are foundational to the existence of the real family. In turn, if you cannot redefine the biological sphere of the family, then you cannot independently redefine marriage and adoption, which make up the legal dimensions of the family, but which are in themselves also derived from the family's biological sphere. The symbiosis between blood and family and marriage is real and cannot be justly broken. The legal applications or definitions of marriage, adoption, and the family must be derived from features of our biological existence. Not one definition can justly be at war with its true biological roots. In the end, and of necessity, biological requirements create social demands, which cannot be rightly altered by any court, no matter what the judge believes or what the motive of their agenda might be. These social demands, which are primal and absolute, are not just a structure of legal convenience designed by judges, but they are determined by the family's biological existence. To help place the deeds of the court in focus, ask yourself this question: why has the court chosen to redefine something as fundamental as the family, while at the same time the justices continue to choose not to allow legal existence for the family? In contrast, the court has not seen a need to redefine the corporation to which the court does grant legal existence. In turn, what about the corporation's rival, the cooperative? The corporation and the cooperative are two institutions whose similarities go far deeper than their names, and which have full legal standing in the courts of numerous nations, but are inherently arbitrary in their definitions. In contrast, the High Court has seen fit to undertake redefining the family, which does not have arbitrary roots. This undertaking means the court has again set out on its familiar path of moral butchery, negating both the physical and spiritual foundations of the family, which, when negated, free the court to engage in a far-reaching perversion of how the family is conceived. These events make it long past time for Christians to define the real family. The family is everyone related by blood, marriage, and adoption. All the court definitions which are arrogantly being used to butcher the family leave out the blood. Yet the blood is the means by which the family has always existed. In turn, every face of every person, and the DNA of every cell in every body proclaim our kinsman-based physical existence. The kinsman blood, the kinsman body, and the kinsman DNA make up the heart of the real family. Our DNA forms a set of specialized libraries, among which there is a vast bioengineering library, a genealogy library, and a court library. Each library within our DNA gives testimony to the fact that our existence is bound up within the family. The family is designed as a set of biologically determined relationships brought about by kinsman events generating our existence. The family is far more than an abstract and fluid invention of convenience by the court. In contrast, the corporation does not exist without the court giving existence to it. In fact, the family existed biologically, socially, and spiritually before the creation of any human court of justice. No court anywhere on the earth invented the family. As incredible as it does sound, and even though the family is the fundamental social unit of all nations, and even though the family exists with or without the court has chosen not to see the family, which means, in the eyes of the court, the family has no existence. Such that even though the family exists without the court has chosen not to protect the family. This is evidenced by the fact that the court has never granted full legal standing to the family. The lack of legal standing is why, in the eyes of the justices, the family does not even exist. Incredibly, courts grant existence to corporations and to cooperatives, but they do not grant legal existence to the family. All of the family law textbooks we have are really textbooks of divorce, which means family law is not family law at all. Now we are ready to make an important point, which cannot be overstated. So heads up. Since the family is not seen as a legally recognized entity that contributes sufficiently to the well-being of society to warrant protection under the law, what business does any court have in defining the family? Said another way, if the family does not legally exist, then why is the court seeing fit to legally define the family? And why is the court defining the family in such a horrendous manner? First of all, these questions mean no court at any level should accept any case that in any way is an attack on the family. Without legal recognition of the family, the court should not hear cases directed either for or against the family, because the real family has no avenue in the court by which it can defend itself, which means the family is essentially cut off from coming to the court to seek justice. For example, a corporation can purchase property and own it through the generations. Yet the family cannot purchase property as a family, because in the eyes of the court, there really is no family. So, does the corporation contribute sufficiently to the well-being of society to warrant this level of protection under the law? Obviously, the court thinks so. But are we to believe the family does not warrant this level of protection? Obviously, the court thinks the family does not. You may strongly believe the family does, especially if you have children, but our courts do not think so. Incredibly, this is the distressing, even alarming state of the family before our court. No wonder the family is in such a state of distress in our land. Can you see the absurdity of the legal situation of the family in America? As things now stand, the family has no legal avenue to defend itself before the court. No wonder the family is being pulled to pieces and our cities are in a moral freefall. All existing court decisions related to the family, especially those redefining any aspect of the family, should be quickly, if not immediately, vacated. There are at least two reasons for vacating the decrees. The court does not grant legal existence to the family, so the court has no business defining the family, or marriage, or adoption. 2. Without legal existence, the family has no real way of justly defending itself or to assert family interests in the court. If the family does not exist in the eyes of the court, what does the court think it is doing by issuing major decrees altering the family? If this situation continues, it is functionally no less than a high court attempt at bullying the holy God for the kinsman dimension he incorporated into the human order at the time of our creation. It is as if the court is intentionally navigating the ship of state into a hurricane. All recent high court decisions on the family imply that, back at the last fork in the road, our court willfully chose the wrong path. Yet time may show this wrong path is being traveled because the court has never been petitioned in its history to grant full legal recognition to the family. So where are our Christian lawyers and judges? They're missing in action on this issue, even with all the legal struggles behind us. Christian families need to organize and create an exacting charter for the family. Then we need to quickly petition the court with the charter, seeking full legal standing for the extended family. The families need to be willing to commit the resources necessary to eventually win the battle in the Supreme Court, and then maintain the victory against all follow-up attacks. This process should be carried out in every nation of the world, beginning with Israel. The lack of legal standing is at the root of the dismantling of the family by our court. In turn, the dismantling of the family by our court is at the heart of the dismantling of our cities and our society. Now we're ready to change gears and winnow out the spiritual principles behind kinsman values. The beauty of God's holiness is revealed in his grafting of the family order. Remarkably, there is a court that does grant full legal standing to the family. This court has primacy over all other courts in heaven and on earth. In turn, this court gives solid legal precedents for establishing the principle of full legal recognition of the family. More than 3,000 years ago, this court even recorded for us the title for the high family office holder. He is our Goel, which is Hebrew and means our kinsman redeemer. The title of kinsman redeemer is not just some esoteric religious concept. It appears more than 100 times in the Hebrew scripture. A complete legal record of the rightful holder of the highest family office is recorded in his DNA. In fact, the kinsman lineage of everyone in the entire kinsman order exists as a legal record in our DNA. In today's world, our kinsman lineage is called our genealogy, but this is a new term and misses the true value of the kinsman record. The kinsman record shows that Jesus inherited the high kinsman scepter at his birth. Then, on the morning of his crucifixion, Jesus received the office of the King of the Jews by written decree of Pilate. Jesus had to receive the authority that rested in this high office if he were to be in a legal position to be justly hung in our place. 1,400 years earlier, the Lord had declared to Pharaoh, "Israel is my firstborn," which means Israel holds the kinsman office of the firstborn nation among all the nations of the world. Among other things, this means Israel is to bless all the nations on earth. And in you, all the families of the earth will be blessed. Genesis 12. Notice in this blessing that the nations are called the families of the earth. This blessing makes Israel ultimately responsible to the Lord for the well-being of all other nations. This kinsman-based legal structure made Jesus, as the high office holder of Israel, responsible before the high court of heaven to bless all the families of the earth. Jesus did so by paying their full sin debt owed to the high court of heaven. Jesus' responsibility for our well-being existed only because the high court of heaven grants full legal recognition to the family. In turn, In a manner similar to the three corporate officers, the high family officer must answer his summons to the high court to pay the debts incurred by all his guilty family members. Amazingly, justice within this framework compels our high kinsman to represent us. Justice also compels our high court judge to accept Jesus' legal representation on our behalf. All this means once the family order was created and once its legal charter was recorded in the high court, justice compelled our redemption. So the Lord has miraculously worked out his loving kindness toward us in his administration of justice. For God did not send his Son into the world to judge the world, but that the world through him might be saved. In turn, justice compels that every human court also grant full legal recognition to the real family. This all means Jesus was able to represent us on the cross as our high kinsman because the high court of heaven does grant legal standing to the family. If the family does not have this legal recognition in God's high court, then mankind is in the same state as the fallen angels, with no hope of redemption. Our redemption reveals the value and the necessity of immediate full legal recognition for the family. You may ask, where do we first find the principle of the kinsman redeemer in the Scripture? The answer is in Genesis 3. And I will put enmity between you and the woman, and between your seed and her seed, and he shall crush your head, and you shall bruise him on the heel. This is the high court sentencing of Lucifer for his first-degree double murder of Adam and Eve. Lucifer is to be executed by the seed of the woman. This seed has proven to be the high office holder within the family order. He will carry out his kinsman responsibility from the court bench that combines the high court of heaven with the high court of earth. In turn, the first one to have ever sinned will also be the last one to ever sin. Our high kinsman will execute the ancient judgment on the one who slew our race. The biological structure of the kinsman order, in combination with the application of the kinsman laws of holiness, will provide the legal instruments through which the end of sin will be justly brought to heaven and earth. This restoration of all things to a state of holiness will be accomplished in such a wise and miraculous way that there will never be another fall into sin. This time, righteousness will be everlasting. You have just read the foundation of kinsman law, which gives rise to kinsman theology, and you have just solved the riddle of the just judge who hung his just son in the place for the unjust.